Hi guys. So it's been a while since I've done a live stream for this group. So I thought, now that I'm back in the United States, I should give it a try. Hi Sai, how are you? Okay, so I have a few questions to go through first. So people posted on in our group when I announced that I was going to do a live stream. So I'll start with those questions, and later on, if you have other questions that you want to add in the chat, then you can post in the chat. I think actually, no, it's better to put your question in the post in the group so I can see it. Because if you put it in the chat, it's gonna get like washed over by other people's comments. So I think it's better if you just put the questions in the group under the post where I was asking for questions. So again, if you want to ask questions, put it in the post underneath the post where I announced the live stream. That way I can see it and get to the questions. So once again, for those of you just joining us, I'm back in the United States. So I thought I'd do a live stream and just to say hi. And I thought today would be a good time because it's the weekend, and that's why I'm in my hotel bathrobe, because all my clothes have not been washed. So I'm sorry. So I have to wear my bathrobe. So I hope it's not too offensive. All right. Well, let's start with questions, and then we'll see how far we get, and then go from there. You can also watch this live stream, which will be saved in a group. So anytime you have to go, don't worry about it. Just go do your thing, and then we'll later on post this live stream to the group. Okay, so 3 things. If you want to ask questions, put it in the post under my post in the group, and you can watch this live stream later. And then number 3 is let's get started. Okay, so we have a first question from Deborah. Deborah says, no, that's not the question. Sorry, that's not a question. That's her suggestion. Her most... declined. Don't they know that I'm doing a live stream? How dare they call me? Just kidding. Okay, so let's look at all comments. I'm still trying to, organize this. All comments. And then, okay. So I guess we'll take the first question from Som, S-O-M, Som Kundu. Okay, the question is, those waiting for work authorization, EAD, if they leave the countries, they go back to their native for a period of time, will it be considered abandoning the EAD and it will be put on hold? The current wait time for EAD for H4 is almost 7 to 8 months without premium processing, and if someone goes out. Okay, this is my understanding. So in order to get EAD for H4, you have to be on H4 status. So if you're just changing your status from F1, F2, H1B to H4, like if you're waiting for H4 status to be approved, and you also file for the EAD, and then you leave the United States, then the change of status will be abandoned. And then it will bring down the work permit as well, because the work permit depends on the status change being approved first. Now, if you're already on H4, but you haven't applied for an EAD, and let's say your spouse's I-140 is approved, and then you decide to apply for EAD, notice that you're already on status. So when you apply for EAD, then leave the United States, then at that point, I think there's no abandoning the EAD because you're already in status. So the EAD is approvable even though you temporarily left the United States. And then there's assumptions that you're going to come back to the United States on H4 visa and then reactivate your H4 status. So you are still eligible for H4 EAD. So there are different scenarios where if you leave the United States, then the EAD could be considered abandoned, especially when you're not on that status where the EAD is authorized to be issued to you. Like in the first situation, if you're F2, F1, H1B, and you're changing status to H4, and at the same time you file the EAD together, in that situation, don't leave the United States. But if you're already on H4 and you apply for the EAD and then you leave and you come back, I don't think the EAD will be abandoned. So there are different scenarios to consider. I think the best answer for that is when you have your own personal situation, then contact us and say, this is my situation. I'm thinking about leaving. Would it impact my pending, employment authorization? So it's not a simple yes or no, as many immigration questions are. You'll notice that a lot of questions I can't just answer yes or no. So this is interesting because some people message me on Facebook and they're like, just tell me yes or no. And I'm just like, I cannot just tell you if it's yes or no because I need to know a little bit more. And maybe they don't like to type. Maybe they don't like to tell too much about their situation. So when I get their information, it's so little. And then they're like, yes or no, yes or no. And I'm just like, I don't know if it's a yes or no until I learn more about the information. So when that happens, I will tell the person, let's schedule a 5-minute call so I can at least listen to what your situation is, then give you a correct answer. Okay. Otherwise, if I just randomly, well, not randomly, but if I just give a yes or no without really understanding the situation, I could be wrong and I could bring you to a wrong place as well. And I don't want to do that. But, for a lot of people who provide enough information and ask a yes or no question and I can answer it, I'll be more than happy to answer yes or no because it takes a few seconds to just read clearly what was written and give the right answer. So everybody, if you want to ask questions, please provide enough context. That way, it's easier to answer with the right question. But this question is good because it allows us to talk about, give an example of the scenario that could lead to EAD being denied. Okay, well, let's take a look at the next question. Next, we have a question from Stephanie. I'm not going to say people's last name only because I'm going to just butcher it anyway because I don't know how to pronounce a lot of these names. So I'm just going to use first name. Well, I'll just say the name that I know how to say well, and then let's just go from there. Okay, so I'm going to mute my computer so there's not that many chiming sound coming in. Okay, all right, so again, for those of you just joining us, you can watch this video in the group. When I'm done, I'll upload it. And also you can ask more questions, just put it under the post and then I'll get to it. So next question is from Stephanie. Stephanie says, first of all, thank you so much for your advice. Oh, you're welcome. So give us more questions, please, so that our group can be more lively. She says her H1 visa is approved and the next step for her is waiting for the documents in her country and set up an interview with the US consulate. I will be working at a nonprofit and the company's case manager told her that her visa is considered cap-exempt. Okay, so her H1B is cap-exempt. So cap-exempt means that the employer doesn't need to go through the lottery, whereas a lot of people have to go to the lottery. So cap-exempt means no lottery, okay? And this is used for employers that are affiliated with a 4-year university. So just by being nonprofit, it doesn't make the employer cap-exempt. There are other requirements as well. So immigration has delved into these requirements more, I think, in a relaxed manner compared to 10 years ago. Right now, even though the requirement requires affiliation with 4-year universities, but they'll consider any contract, any agreement, anything that the employer has with 4-year universities, to determine if an employer is cap exempt. Okay, so her employer believes and told her that they are cap exempt, which means that they don't have to go through the lottery. And let's see what else. I wonder what the timeline could be. Okay, so for an H1B cap exempt, generally, for example, I don't know what other lawyers are doing, but for me, we file the LCA generally within 1 week. And then after that, the LCA is certified after 1 week. So 2 weeks, you can see preparation, file LCA, 1 week, another week. During this week, we're probably going to be done with the petition. So when the LCA is certified and returned back to us, then we can file the H-1B petition. So maybe 2 weeks, sometimes 3, depending on how long it takes the employee to give us some of the vital information. Because sometimes employers don't respond very fast. So when we ask them for information, it takes them a few days to get back to us. Then it slowed us down a little bit. Oh, hi, Indu. How are you? Nice weekend. Okay, so that's kind of about, I would say 2 to 3 weeks is a timeline to file. And then if you use premium processing, then you'll get the decision in about 2 weeks. If you don't use premium processing, then probably about 5 or 6 months. Maybe 4, depending on, because right now it's H-1B season, so USCIS could be a little faster with their H-1B adjudication. So it's going to be, either premium processing or non-premium processing for 15 days, and that's business days. And then, or you don't do premium processing in a few months. She also asked, if the interview goes well, do I just go straight to the US? I would imagine, yeah, if the interview goes well, then you get a visa and your passport and you just fly to the US. That's the next thing. What does the process look like? So I don't know who's assisting with your visa application, because you have to go online and then fill out a form called DS-160, choose the right visa category, provide personal information, schedule an appointment with the US consulate, go in, talk to the officer, verify your position and salary and all that. And then you get the visa stamped, and then you come into the United States. That's what the process looks like. Okay, so next we have a question from Joel. I believe I spoke to him before. I got in a group, we had a conversation. I think he's Australian. Okay, I hope I'm remembering the right person, because I think I remember him, but that's okay. Let's see what he said. Let's see what he wants to know. Okay, hi Jack. My spouse is living and working abroad in Australia, 2018, 2021. Okay, so I think I remember the right person, because he mentioned Australia. And she's waiting for her Form 1040 after recently submitting her 2021 tax return. She hasn't filed U.S. tax return for 2018 to 2020 yet. She was paying Australian taxes. And I understand the streamlined filing could be costly. So we are planning to file 2018, 2020 in a few months when we have more income. Okay, so I'm going to pause there and say immigration only just looks at your most recent income and most recent tax return. So you don't actually have to file all 3 years, contrary to some people's beliefs. So to pass the affidavit of support, they look at current income. Current income means how much is the petitioner making in 2022. Now, the tax return from the previous year will assist immigration in figuring out the petitioner's current income. So just the most recent tax year. And now, just to provide a little bit more context, Joel, I believe, is applying for a green card within the United States because his spouse is a U.S. citizen. So this is called an adjustment of status, which requires an affidavit of support. And that is why he's asking about the tax return, because on the I-864 affidavit of support, it asks you to fill in your income information from your tax return from 2020, 2019, and then 2021, the 3 most recent tax year. So that leads people to believe that they have to file taxes every single year to qualify as a sponsor for the green card, which is not true, because if you have the most recent tax return from 2021 and you have the W-2s from 2021 and pay stubs from 2022 to show that your current income is above the federal poverty guideline, then your sponsorship will pass. You don't need to have every single year tax return before that. I mean, they're helpful, but they're not required. So I wanted to make sure. All right, so Ismail, I see your question, and right now the phone is kind of far away from me. So if I want to read your question, I have to use the binoculars. So why don't you copy and paste that question to the post in a group under where I was announcing, the live stream, and then I'll be able to get to your question after everybody else's question. And there's only 15 questions now, so I should get to your question pretty soon. So go to the group, find my photo where I said, hey, I'm going to do a live stream. Post your question underneath there. And this goes for everybody else who is going to ask a question. So try not to post it in this chat, because my phone is far away from me and I have to use a binocular to see what you're typing, and it would be difficult. So, and I'm like Jabba the Hutt right now, so I'm just like, stuck to my chair. So I'm going to ask you to post it in a group underneath my post where I'm announcing my live stream. Thank you. Okay, so back to Joel. So he's applying for adjustment of status, which is a green card application because his wife is a U.S. citizen. Now they have a question about affidavit of support, and the gist of the question is: do I have to file tax return? Does Joel's wife have to file tax return because she's a U.S. citizen for 2020, 2019 to qualify for affidavit of support? The answer is no. If your current income is above 2020, is above the federal poverty guideline for 2022 and 2021, you should be fine. Okay, so let's read on. He has a little bit left. He says, can my sponsor still sponsor me and submit I-130 if she hasn't filed those years' tax return? I already answered that question. So I anticipated the question, knowing exactly what it was, and answered it. So great. Okay, so let's move on. Next question we have MD Labib. Okay, I think I can say that pretty well. MD Labib, how long does it take to visa interview after the approval of I-140? Depends. See, this is where I don't have an answer unless I know, first of all, where were you born? Because different country of birth can affect how long the interview is going to be. For example, if you're born in India, then after filing I-130 to the interview could be a decade or longer. If you're born in Saudi Arabia, then it could be 6 months. 6 months is a little too optimistic. Maybe a year, because it has to go to NBC first, and then you upload the documents, civil documents, and then and then they're done with NBC, and then forward the case to Riyadh, and then for your interview. So since there's no waiting time, if you're born in Saudi Arabia, then it could be less than a year to get to the interview, maybe even faster. So how long does it take to be an interview after the approval of I-140? Depends on where you're born. It could be as short as 6 months to a year, as long as 10 years or longer. So see, can't really answer that question until we have more context. Now, oh yay, I see you posted in the right place. Thank you. Okay, next question. We have Rituraj Sarma. He asks, I have got the approval for H1B with I-797A and it starts from October 1st, 2022. Wanted to know how early can I go for stamping? You can go for stamping now, but you just cannot come in with the H1B visa until after September 1st. There's this rule that you cannot come in too early before H1B starts, and H1B starts on October 1st. And what I mean is it's valid after the new fiscal year starts, which is October 1st. So you can go and get the visa stamp now, but the visa you cannot use the visa to enter until 30 days before H1B starts, which is September. But I have seen CBP admit people in August as well, because CBP officers, they're not all like smart. So sometimes they just didn't know, and then they make mistake all the time. So I would say don't get the visa too early, because the visa is only for 5 years. So if you get it early, then you're wasting that time. Like if you get it in August, then it will be valid for 5 years from August. But if you get it in June, then it'll be valid for 5 years from June. So you'll be wasting some time, I think, if you get it too early. Next, he asked, is it possible to go for stamping anytime in August or September before H1B kicks in? The answer is yes. You can get H1B stamped before it actually kicks in on October 1st. Okay, so let's take a look at next question. There's a greeting from Linda Jane. So hi Linda, and no questions. I'm going to move on to next question. Next question is Tamojit. Okay, Tamojit asks, hi Jack, first of all, thanks for hosting a session. You're welcome. I'm expecting to receive my I-140 by end of this year, okay, or January 2023. My I-797 is valid till October 2023, okay? Once my spouse, she's in H4 status, applies for H4 EAD after I get my I-140, will there be a concern? as it is taking more than 5 to 6 months to get the EAD approval. I'm not understanding the question yet, but let's see if I understand by reading more. The reason I am asking is that it will be just a touch and go, just within October 2023 by the time she gets an approved H4 EAD. Oh, okay. I don't think it's a concern, only because once the I-140 is approved, then you can file H1B extension and H4 extension after October 2023. So she will get an EAD that's valid for 2 years, but the EAD is based on her H4 I-94. So if you're not filing the H4 extension, she really shouldn't be using the EAD. I don't think immigration is going to give an EAD that expires in October. If you're worried about that, then I really don't. I have not seen that happen. But if you're worried about that, you can file the EAD with the H4 extension. But that's going to delay the EAD because you can only file H4 extension 6 months before expiration day, which is going to be what 6 months before October is April. So you can only file extension in April, but then you already got your I-140 like in January, so you're wasting this time. So you might as well file the the H4 and H4 EAD. She's already in H4, so just file the EAD, and then when it gets approved, if it's less than 2 years, file an extension like in October with the H4 extension. I think they're gonna give 2 years. But it's just a matter of monies to file the extension and having to do the EAD again. So I honestly don't think that it's a concern, because when it comes to like, I can resolve this issue with just paying more filing fee, then it's not really a concern. It's just, it sucks, but it's not a concern because I just pay it and file it with my extension. Okay, and then he also asked, however, by the time I'm already apply for my H1B extension from my employer. Oh, okay. So that's just to add to it. So I think he is aware of the same thing that I'm talking about. Just file the extension and it should get approved. I mean, even if the previous EAD is approved for a short time, file an extension and it'll just get extended. And I don't see a concern. I just think that you have to be mindful of the timeline, but it's not really a concern. Okay, next we have Andrea Jimenez. Okay, she asked, how long does the status change from F2 to H4? She says visa, but she really means status because you can't change a visa. You can only change a status. So someone's already in the US and this person's on F2 status, and then they want to change status to H4. So, and then she adds, if the H1B will get the visa October. So in this situation, there's a change from F1 to H1B, and then the spouse from F2 to H4. She's asking, how long does F2 to H4 change of status take? Well, we know that the primary change of status is going to be quickly because there is a premium processing for that. But for F2 to H4, there's no premium processing. Usually USCIS will try to approve it before October 1st. It could be a little longer. And I think that most people are worried, what if my spouse's H1B change of status is approved and he goes into H1B status, then how can I stay in the United States? Well, you can stay in the United States because you still have a pending change of status application to H4 that has not been resolved by USCIS. So you can stay in the US and just wait for the decision. I would say on average, it probably will take about 6 months to 12 months for a change of status. And since June 1st, there's going to be a premium processing available for change of status to H4, I believe. So I will look into that. Don't quote me on that yet because the change of status new policy is a mess. We know that they're going to do change of status premium processing they're going to do change of status. They're going to do premium processing for change of status, and that means non-immigrant status. But there might be conditions like, you have to have filed it before a certain time, and it's pending too long, so then we do premium processing. So I would first look at the premium processing and see if there's any conditions attached to premium processing the change of status from F2 to H4, which I think will speed things up if you're worried about not being able to change status quickly like your spouse. So, but I would say you probably don't need to worry about this because you can stay in the US and just wait for a decision. It will come. It might take a little bit longer, but since you can stay in the US anyway, unless you have to travel, if you need to travel, even better, you can go home, get the H4 visa and come back in, then you're immediately H4 and you don't have to wait for the H4 change of status. So I would say in all considering, it's not a concern that it's taking a while. Yes, it's taking a while. Yes, it's about 6 months. I'll focus on her question. Her question is only how long does it take? I myself think it's going to be like 6 to 12 months, but I would also look into premium processing because there might be a premium processing available for this type of application in the near future. Okay, next question we have Ramakant. Ramakant asks, can a person who applies for change of status from H1B to F1 and got his F1 approved before graduation eligible for OPT? Yes. So this is actually something that I didn't know before until a couple years ago. That like if you're on H1B and then you study, and then you file a change of status. If the change of status is approved before you graduate, you can apply for OPT. But if the change of status is approved after graduation, then you cannot apply for OPT. So there's a big difference because the OPT rule only requires you to be on academic year for one year, and you could be on academic year on H1B. I thought previously that means you have to have F1 status for a whole year, but no, I think I was proven wrong. So that was interesting, and I learned this lesson about 2 years ago. So the answer is yes, but what's really tricky about this is that change of status from H1B to F1 takes forever. Sometimes, I've seen cases pending for 18 months. It's crazy, ridiculous. But since June 1st, there might be a premium processing available for this type of application as well. So to answer Ramkant's question, yes, you are eligible to apply for OPT if your change of status to F1 is approved before graduation and your I-20 becomes effective. So yes, I've seen that before. All right, let's move on to the next question. Next question we have Farah or Farah. I don't know how to say that properly, so I'm gonna say it both ways. Farah or Farah. I think Farah sounds better because I've heard Farah before, but I don't think I've ever heard Farah. Okay, Farah. Hi Jack, my I485 is pending. I got a leg injury due to a negligent dog owner who left it unleashed. Ooh, sounds really gory. Okay, I didn't inform the police at the time of the incident, thinking of the consequences he may have on my I485 application. Why not? I mean, you're a victim of a dog. It's not going to affect your I485. It's not like you did something wrong. So I don't know, that kind of thinking makes no sense to me. I mean, if you're a victim, you should definitely, I mean, I don't mean like report it to the police, but definitely, initiate maybe like an insurance claim or something against the owner so you get paid for the injuries. All right. She says, since USCIS is overtly into tickets or legal issues of applicants, would it affect my application if I get involved with the police? No, absolutely not. I mean, you're a victim. You would be served. I mean, it would serve your interest to report it to the police because, there might be insurance claims available or compensation. And this is a civil action. Even if you were criminal, I mean, you're not the defendant. Like, you didn't do anything wrong, so it's not going to affect you in any way. It's not going to affect your I-485 in any way. So I would say report it to the police before it's too late. Okay. Next, Linda Jane. Linda Jane asked a question. Hello, Jack. We submitted our adjustment of status this year, January 14th. We're here in Minnesota in the USA. Our cases are at National Benefits Center. So start with IOE. IOE is a receipt number for all the online-based applications. They have this filing. filing number starting with IOE. We had biometrics April 7th and absolutely nothing since. Okay, well that's normal because you're not going to get the EAD. Well, the next thing is the work permit, right? And the work permit comes in about 5 months from filing. So January, yeah, so just about now. I think in June or July you're going to get the work permit if you file for work permit, and then the travel permit. But the travel permit now takes like 13 to 15, well, 12 to 14 months. So you might have your green card already before you even get your travel permit. So let's read on. Linda says the I-765 still shows fingerprint was taken, but the I485 and I131 say actively reviewing. Is there any way at all to get our case moving faster? It's moving just fine. Like paying premium processing, there is no premium processing for family-based adjustment of status, unfortunately. I wish there is, but there isn't. Let's see. We feel stuck in limbo. I mean, you filed in January and it's only been 5 months. You have to have realistic expectations of how long these applications would take. I just did a family case where U.S. citizens, some petitioning parents, we waited for 14 months until there was an interview. So I would say, oof. Yeah, well, she says she can't get a driver's license. Well, I mean, you get that after you have the work permit. I applied, but they said we need social security number. Well, yeah, after you get the work permit, you get a social security number, then you can go and get the driver's license. We can't even do voluntary work as they can't process background checks. Well, I mean, that's why people are advised against coming to the US and doing adjustment. If you waited in your home country for the immigrant visa and you get it, and then you come here, you're already a permanent resident. You get social security, you get a green card, you can do whatever you want a lot faster, which is why we don't really advise people of age to come here and do adjustment. When I say people of age, I mean like people who are seniors. Why? Because when you come in on a visa waiver, it would be difficult for you to get insurance because you don't have social security number for many months, and you can't work, you can't drive, you can't do. So it's going to be very inconvenient, and also it takes a while to get the travel permit if you have an emergency to go home. And operations and medical care in the United States could be very expensive when you're here without social security number or legal status. So this is why don't come here and do adjustments if you're not prepared for all of these consequences. No driver's license, can't work, no social security for several months, can't travel for several months. You have to understand, like, this goes to everybody. If you're thinking about coming to the US and apply for adjustment, please know that you're going to have many months of not having any documents to live in the US. You can stay legally, but no social security number until the work permit. You probably can't open a bank account unless you work with a bank that has a branch in your home country. You can't get driver's license in most states. You can't get a social security number. You cannot do volunteer work. I mean, there's just so many restrictions. So again, no premium processing, sorry. Linda says, our field office will be Minneapolis St Paul. Right now it's saying approximately 19 months. I would say probably 12. I mean, nowadays, USCIS post these extremely long looking processing time, but usually it's not that long. Okay, so that's all that's being asked. And then next we have Pune, who's my client. So I already answered a question. I will discuss with her privately. It's about processing time, so you can look it up online. Even though it says that's not online, but actually if you just look at the average processing time, it will do. But right now, if anybody wants to know, the I-751 is a mess. I-751 is a removal condition application. So if you get married to a U.S. citizen and they give you a green card within 2 years of your marriage, and they give you a conditional card for 2 years. And then you have to remove the condition to turn it into a 10-year green card. This application is the I-751. And nowadays, it could be as quickly as 6 months if you have like 10 houses together and 100 kids. Well, obviously, nobody has that. So it would be very rare for an I-751 to be approved within like 6 months. But I've seen that, yes, with people who have like overwhelming evidence. And then on average, it takes about 1.5 to 2 years. Now, some things could cause this processing time to be longer. For example, if you filed in 2020, because a lot of 2020 cases are hopelessly delayed because of COVID. So if you filed in 2020 and you waited for more than, a year and a half, you probably will be waiting a little longer, but just keep following up. It will get there. It just takes a while. All right, let's go to our next question. We have a question from Serenity. Oh, I love that name. Serenity asks, "Hi Jack, thank you for being so awesome." Oh, you're welcome. Okay, I filed I-130 September 2021 for my dad after I found out he has stage 3 lung cancer. Oh no, sorry about that. Now he finally made it to the United States with a B1, B2 visa. So what's the next step? File Form I485 adjustment status? Yes, file it as soon as possible, because he's eligible to apply for adjustment now that he's in the United States. So because processing from China, which I'm guessing China only because I'm from Taiwan, so I know based on the name that this person is probably from China. It takes forever to process immigrant visas from China because the Guangzhou consulate, which is the only consulate in China that processes immigrant visa, is very backlogged. So he's here on a B1, B2 visa, so he can apply for adjustment of status. Now, some people say wait 90 days after he comes to apply. I say don't worry about it, just wait maybe 30 days, because you don't want to apply right away after he lands, because he's still using a non-immigrant visa. So you don't want it to seem like he came here just for the green card. But if you file anytime after 30 days, should be pretty safe. So I would say do the I-485 now as soon as possible, because waiting any longer isn't going to help with the situation. Okay, next question we have Anand. Anand asks, "Hi Jack, hope you're doing well. Question, my wife is a permanent resident since June 2016. She was out of the US more than 6 months. So between July 2016 to June 2017. That's almost a year. Okay. When will she be able to apply for her citizenship? Okay. So let's hash this out. 2016 June, she was well, first of all, I don't know how she got her green card. I assume it's not marriage, okay? Or if it's marriage, then she would have, okay, well, let's talk about both situations. Let's say that she got her green card through marrying a US citizen, a non, for example. Then she can apply for citizenship in 3 years. So she got her green card June 2016. That means she can apply for citizenship in June 2019. But she had a lengthy departure. So from July 2016 to June 2017. So the rule says that you have to wait 2.5 years from the time you come back to the United States from that lengthy departure to apply for citizenship. She came back June 2017. So June 2017 plus 2 years is June 2019 plus 6 months is December 2019. So she should be able to apply now. Okay, so if she got her green card from a citizen spouse, a non. Now, if she didn't, and she got her green card some other way, then she needs to wait 5 years to apply for a green card. And she needs to have 2.5 years in the United States, which we assume that she does. I don't know from the fact pattern, but so we have to assume that she has 2.5 years. Now, she has an absence between July 2016 to June 2017. So that means you have to, immigration law asks you to wait 4 years and 6 months from the time you return from this lengthy absence to apply for citizenship. So that's 2017 plus 4.5 years. So 2017 plus 4 years is 2021 June, plus 6 months is 2021 December. And we're already in 2022. So in both situations, she seems to be qualified for citizenship already. Questions answered. All right, so next, let's see. We have Sade. Oh, another great name. Sade asks, what restrictions, if any, exist working on an EAD while I-485 is pending? I would say pretty much none. Okay, she recently got her EAD, AP combo card, and would like to change employers. Besides the new employer's lawyer filing I485J. Okay, when I see I485J, I know that she's applying for a green card through an employer sponsorship, not a family-based. When I first started reading the question, I thought it was family-based, like she's married to a citizen and then she got a combo card. In that case, there's no restriction. But in an employment-based situation, you need to make sure that the I-485 has been pending for more than 180 days before you take the EAD to the next employer. Because if you leave too soon and your employer withdraws the I-140, then your green card application cannot be ported to the new employer and you might have to start over. So there's that restriction. On the EAD when you got it through employment-based sponsorship. Okay, we have another person, Monio. I see your question, but in order for me to read it, I'm going to have to use a binocular because I'm really far away from my phone. So can you copy and paste it to the post where I announced my live stream? Underneath it, I'm done with all the questions now, so I'm getting to the new questions. So if you post it now, I should be able to get to it within the next 10-15 minutes. Okay, so let's see. All right, I believe there are a couple more questions. Okay, so that's Sade. Sade, wait 108 days from the day you file the I-485 to change employer, even if you have an EAD a little bit earlier than that. Okay, all right, next we have question from Sai Kiran. This name sounds very familiar, so I think I've answered questions before. Hi Jack, thank you very much for hosting this. I'm happy. I'm applying for H1. 100,000 K is still wage level 1 for my job position. So I'm applying in wage 1. Wow. Okay, would like to know how it would impact H1B application. So there are different level of wages, and everybody always wants to know what level wage am I. Now, I would say don't worry about what level of wage you are. Worry about level 1 only, because level 1 wage means your entry level position. So if you're entry level, you get paid the lowest, which is level 1. Now, when you go for H1B and it looked like you have a master's degree, you have a bachelor's degree, maybe you have a second master, you've worked on OPTs for several years, and you're level 1, does that make sense? I think that's where the challenges might come from USCIS and say, how can you already work so many years and still level 1? How still entry level? So in that case, they might start questioning the position because they might say, well, it's entry level, so we don't think it's specialty occupation. We don't know what it is you're doing. But I think this concern is less so when your salary is already like $100,000, because no matter how you look at it, entry level or not, it should still be a specialty occupation because the wage is so high. It's 6 figures. Okay, this type of level 1 problem usually occurs when your offered wage is like $30,000, for example, and you already had a couple years of experience, and the salary, your employers is not raising your salary. In that case, I think there's a high suspicion that this position probably is like flipping a burger, where it doesn't really require much, so it's such low wage, it's entry level all the time, then probably not suitable for specialty occupation visa like H1B, which requires high level of sophistication, education, and experience and skills. So in this case, I would not worry so much about $100,000 wage for level 1. But it's still level 1. So if you get an RFE, you have to be able to respond with enough details to show that this is a specialty occupation despite having a level 1 wage. And it could be a somewhat difficult RFE to respond to. But if your employer has a great legal immigration team, they should probably have samples from different sources to put together a great response for this type of, because immigration only requires level 1 wage. So if your level 1 wage is already 6 figures, chances are this is a specialty occupation. Somebody just has to explain to immigration that they're wrong in thinking that it's not. So that's all I can say because I don't really have a lot of data or information about the position or the employer to say anything more. So we'll stop there. But we offer this type of service. So if your employer is like, I don't know how to respond to this, and they got an RFE, then we can help them respond to it. Okay. Next, we have a question from Ismail. Ismail says, my I485 Pakistan, so he tells me where he was born. So that really helps. Case was transferred from Nebraska to National Benefit Center. Case was filed December 2021. Are you seeing faster processing for I485 cases at NBC? Well, generally, NBC is a little faster than, say, like Texas Service Center or Lincoln, but I don't think it's that big of a difference, if you ask me. Also, I asked my school to close CBIS since I-797 was approved. Was that the right decision? Since I-797 was approved. What I-797? Are you talking about the I-140 I-797 or an H-1B I-797? I mean, you already filed the I-485, so you don't need the F-1 status anymore. But we usually recommend that, at least for our client, that they keep the F-1 going, because if the I-485 gets denied, at least you still have the F-1 and can continue your status and continue to stay in the United States. If you let go of your F-1 and your I-485 gets denied, boom, you're out of status. So there's that risk. So these days, I get so many people asking me, should I stop my file getting transferred to NBC, or should I file I-140 first, get it approved, then file the I-485 so that it doesn't go to Texas? I think it's just too much speculation. What I think is that when you file for adjustment, you should think to yourself, based on an I-140 and your priority date is current, then think to yourself, okay, I'm going to wait a whole year for this. Okay, in some places it's 8 months, some places it's 10, some places it's 11, some places it's 14, some places it's 16 months. So, and then this kind of thing changes all the time. Like an 8-month place could suddenly be 12 months, like in a span of a month. So spending all that time tracking about doing this, filing this first or filing that first, maybe it doesn't go to the service center, I just think that it's a waste of time. Because when a service center gets backlogged, USCIS will move some of its cases to other places, okay, so that they all have a balanced workload. So thinking about, I'm gonna like stuff it over there, and then later on when everybody stuff it over there, what happens? If that place becomes backlogged, then USCIS transfers it to another place. So spending all this time thinking about, oh my God, how long is my application going to take? How long is my application going to take? I just think that it's a waste of time and it brings so much anxiety. You might as well just know, okay, it's going to be 1 year for EBAOS. And if it goes over 1 year, follow up on it. It'll come and you have a work permit, you can change employer, you have a travel permit, you can go anywhere you want. So spending all this energy, like trying to push it somewhere else, to me, it's so pointless with some of the applications. Yeah, because some of our clients, they're like, especially like with the I-751, they would message me and say, why is it at this place? Why is it not over there? I'm just like, well, why do you care where it is? I mean, USCIS has it. They're going to review it. They're going to get back to you. The average time for I-751, for example, is 1.5 to 2 years. So before you reach 2 years, then don't worry about it. If you reach 2 years and you still don't have an answer, we'll follow up with USCIS. Again, a lot of cases filed in 2020 are taking more than 2 years, for the I-751. It is crazy, but you're still a permanent resident. You can still travel. You can still work. And you can apply for citizenship if you are eligible. So, like, why rush to anxiety worrying about where your application is and how long it's going to take and trying to push it to some service center that you think is faster? I think it's just all a waste of time. And it just creates unnecessary work and anxiety for yourself when USCIS doesn't push it, because USCIS has their way of distributing the work. If everybody gets sent to one service center, then that service center is going to get backlogged. So try to push it somewhere. I just don't think it makes any sense. All right. So let's move on to our next question. We have Monil. Yes. Wait, Saikiron, I think, asked a follow-up question. Okay, well, let's get to Saikiron's question. Let's see. I already forgot what he asked earlier. What did he say earlier? So Sai's question is about, the level 1 wage. Okay, so he says he has a full-time job offer as well, who's wanting me to join, but I want to get my H1B approved before I change. What? Is this an H1B extension or an H1B change of employer or a capped H1B? Because if you just won the lottery, you can't change until after October 1st. Again, probably not enough context. Can you please let me know the transitional process if I want to take up the full-time job? Well, I need to know if this is... Oh, hey, Deborah. I think I answered your question. So, I already answered your question. So I'm going to post this video online and you can watch it and you'll see your questions answered because I answered your question earlier. So you don't have to repost it. So back to Sai. I don't know what... Okay, fine. Let's just talk about both situations. If it's cap-exempt, which means you're already on H1B status, you're just changing employer, then you just have the new employer file a change of employer petition. If you're cap subject, you just won the lottery, and you got it approved, then you have to wait until after October to change employer. Okay, so Pune, is it okay? I can't really read it. Can you post it to the group, because I can answer this question after because I don't want to be answering 3 questions at the same time. So post it to the group, to that post where I announced the live stream, and then I'll answer the question. So back to Sai. He says, follow up on the old question, can you please let me know typical things we need to take care for students applying who pursued CPT route? Okay, so the only thing you need to take care when you are on CPT or have done CPT is to show that during that time you were actually regularly attending courses. So USCIS wants to know, like, you've flown to classes if your CPT was before the pandemic. If it's after pandemic, then they want to know, like, you attended online courses, maybe there's attendance records, the school has some tracking records, maybe there's assignments that you can show them, test scores, transcripts, and I think I already mentioned attendance records. And then if you bought books for the courses, you can show them the receipt for the books. Save all the books, okay? And then save the handouts, save the notes, so you can show them some samples of, like, you were actually in class, because the only issue for CPT is that you were regularly attending courses. Why does USCIS care? Don't they assume that you're in classes? No, they don't. Why don't they? Because you live very far away from school. So to USCIS officer, they're like, how can you go to school? I mean, you live in New Jersey, your school is friggin' in California. Like, do you fly to school? Like, in their mind, they're thinking all students have to attend classes in person. But if your class is remote because of COVID, how do they know that you're in class? They don't. You live far away from school, first of all. You work all the time. Like, you're on CPT, you work probably full time. You work a substantial number of hours. How do you go to class, like, on top of these things? That's what they want to know. So, what things we need to take care for students applying for change of status to H1B while after pursuing CPT? Show evidence that you were in class, remote or in person. It's very important, because half of the RFEs we see on people who use CPT were asking for evidence that the person actually attended courses. They were physically there, or they were attending online courses. In that, you would submit attendance records or books that you bought, maybe copies of handouts or notes, assignments, test scores, attendance records, just as many things as you can to show that you were doing the classes. Some people ask me, is screenshot of the classes helpful? I don't think so, only because anyone could have screenshotted that scene, that one moment. Somebody could have sent you that JPEG, and then you said, I was in class because I have a screenshot of my class. I don't know. That doesn't persuade me, because it's a screenshot. Anyone could have taken it. But if you bought books and you have attendance records and you have test scores and you have assignments turned in, I would say, well, chances are you're in class, because you wouldn't have been able to do all this when you're in class. So I would say forget about the screenshots, but if you have documents to show that you were actually regularly attending class, that's what they need for CPT. But that's a great question, because this question is red hot right now, because in the last few years, USC has been sending out these CPT RFEs like candy to everybody, because they just cannot fathom how these people are going to classes when they live thousands of miles away from school and they're working full time on their internship. So it's like, okay, how are these people attending classes? Tell us. So be careful about that. All right, so next question. Sorry, we're making people wait for a long time. So let's not have any more follow-up questions. Let's just, if you have follow-up questions, reach out to us privately so that we can discuss more. Next question we have from Monil. Is it quicker to get a visa through consular processing or through adjustment status? Great question. Depends on where you are. He's applying for EB3 green card, priority date is current. If you're from a country where it's going to take forever to get an appointment, like China, like Canada, or India, then you probably want to do adjustment of status in the United States. It's faster. But it also has to do with where you live in the United States. For example, in Los Angeles area where I practice, it's pretty fast. I would say 10 months. So when you pit 10 months against Canada, which takes 18 months, definitely choose 10 months. But if you live in Seattle, where it takes 18 months to get an adjustment approved for an EB3, and you're from Japan, and it takes 10 months to get the same thing from the Tokyo U.S. Embassy, then you choose the 10 months. So it really depends on where you live and where you're born, where you'll be going to get the immigrant visa. And one thing about the immigrant visa is you cannot do a third country processing. You have to go back to your home country. And your home country is defined by the country that issued you the passport. So if you have multiple passports, then you will be able to... So Monil says he's in Texas. Texas is terrible. Slow as hell. So there is Dallas, there's Houston, and there's Austin. And I think San Antonio as well, but I have to look up. I don't think San Antonio has their own field office. Hold on. Sorry, I just have to look this up because it's bothering me. Is there an office in San Antonio? I think there is. They used to have this nifty map that I can't seem to find anymore. Field offices. Okay. Gosh. Okay. They don't have that map anymore. All right. I know. I can look it up from the processing times. So if I select I485 and then I go to family base, and then I go to the offices, San Antonio, there is one. Okay, so there's San Antonio, there's Dallas, there's Houston, there's probably Austin too, so there's 4 field offices. So there isn't one in Austin. I was wrong. Okay, so just Dallas, Houston, San Antonio. I think that's it. And they're all really slow. So close to Dallas. Okay, really slow. So, well, then the next question is, where are you going for the immigrant visa, right? I mean, are you going for something that that's really fast? Like, I mean, nowadays it's really hard to find a place. Like I know, like where I'm from, Taiwan is pretty fast. Japan is pretty fast. I think South Korea is pretty fast. But a lot of these other countries could take a long time. So I don't know. I mean, I would say like if you're in the United States, um, you probably would just try to do adjustment because judging by your name, you're probably from a place that's going to take forever. India, oh, okay. If it's India, then I would definitely do adjustment. Yeah, because India is just so slow. Um, India is like the busiest country, you know, like for visa issuance. So I would never go there. I would never choose to go to India if I can do the same thing in the United States. Okay. Now, Deborah, I think, uh, sorry, I'm trying to read. Gosh. Is there a way to actually speak with a live person when we call them? Yes. You have to say info pass to get through to a live agent. Info pass is the magic word that you would say to get through to a live person. Okay. Now, our next question is from Tito. Tito says, my old visa expired and new H1B with a different company needs to get stamped. I got an October date in India, but my father is in the hospital in India and I need to go immediately. Is there a way to get an earlier date? You could just go now and then wait in India till October 1st. If you want to get a faster date, you have to have an emergency. So your employer would have to write you a letter that says, if Tito cannot come back before a certain time, we're going to lose millions of dollars because of this. Then I think that the US consulate in India could give you an earlier date. I know this consular processing lawyer that my old firm used to work with. She's great at like doing the emergency expedite for visa appointments. I would say like if you need, I can refer you to her and see if you guys can come up with the evidence necessary to establish an emergency to get a faster appointment. She's been amazing. The I feel like when I write to the consulates, they don't respond to me very quickly, but somehow she's able to get responses very quickly from some of the consulates. I don't know how she does it, but maybe it's a relationship thing because she's been traveling around and attending all the consular events. So she has connections. She knows the people, especially Canada and Mexico. But I'm not so sure about India, because it's kind of difficult to go to consular events in India because India is just a country that you need to have a lot of preparation to go to. So I don't think that. I mean, you could try. But you need an emergency to get an earlier date. So is it possible to get an earlier date? Yes, but you need to have evidence of emergency. They won't just move you because if they move you, they have to move everybody else and nobody gets expedited. Whew. Okay, so give me a second. Okay, so let's see. Oh, that's the last question we have, I think. Let me check it one more time. Yes. Okay. All right. Well, I'm gonna just see what people are saying. Is it possible to choose a different service center which processes the application quicker? No, there isn't. Or is it decided based on where the I485 is filed? Or it depends on where you live in the I485. And I think it also could depend on the I-140 filing location, like where the employer is located. Because nowadays the I-485 is centrally collected and then they distribute it based on workload. So there is no way to choose. And again, I'm just going to say this again because trying to choose a service center makes no sense because you're slow because you live in Texas. It's not that you're slow because you chose the wrong service center. No, you're slow because your application processing time is very slow because you live in Texas. And Texas is really slow because there are a lot of applicants. And when the immigration allocate time for that location, they need to give it more resources, but then they haven't, so it's slow. So trying to choose a different field office or a different service center doesn't make any sense. What would make more sense is if you move, like let's say you move to Los Angeles, or if you move to, where is fast? San Bernardino is really fast. So if you move to a faster location and live there, then you probably will see your application process faster. But I don't think a lot of people would do that. I mean, it wouldn't make sense to move for an immigration application. It doesn't matter that, I mean, the time difference isn't that great, in my opinion. Okay, so I think that's all the questions. And it's been a while, it's been fun. We'll do this again some other time. So I will again announce that we're gonna do a live stream, and then people can just put their questions, and then once we have enough questions, then we'll do a live stream. All right, everybody have a great weekend, and continue to put your questions in the group if you want any answer in writing or want people to share their experience, and feel free to reach out to us for consultations if you want a more in-depth analysis based on your exact scenario. All right, thank you and have a good day, guys. Bye-bye.